Do you swear or affirm the testimony you're about to give us the truth?
I do.
Please proceed.
Hello, Chair Schroyer and members of the Land Use Commission. My name is Shelly Muneoka. I am submitting testimony today in strong support of the Kanahele's petition on behalf of KAHEA, the Hawaiian Environmental Alliance. KAHEA has engaged various administrative and legal processes in the protection of Mauna Kea over the last decade, and now come before you to ask that you address an error that has resulted in irreparable harm to one of our most sacred places. The university should not have been allowed to build one observatory after another without coming before this body to ask and hopefully be denied for a boundary amendment to change the Mauna Kea Summit area from a conservation district to an urban district. I feel sick even saying those words because that is de facto what has already happened. To be completely clear, we are not advocating for the urbanization of the summit. We are saying that UH and any other applicant should be required to apply for a district boundary amendment to conduct land uses inconsistent with the conservation district designation, like constructing 14 industrial astronomy facilities or even a single 18-story one. Applicants cannot be allowed to industrialize the conservation district by simply avoiding the LUC altogether. If BLNR indeed has the authority to determine allowable uses therein, it should go without saying that their authority does not extend to permitting non-conservation uses within a conservation district. I'm going to skip that. I'm going to jump around a little bit in the interest of time. I wanted to address, as they speak about in the petition, Mauna Kea as a wawakua, as Ku'ule describes the elemental forces and functions that create these godly realms. And just wanted to draw a parallel between a wawakua and a conservation designation. Both means that those places function best without a permanent physical human presence or impact. And unfortunately, it's an uncontested fact that the cumulative impact from industrial astronomy on Mauna Kea has already been substantial and adverse. Perhaps the concept of non-use is an uncommon one, or non-entry is an uncommon one for this body, but for many families like the Kanaheles in relationship to Mauna Kea, that non-use or non-entry into an area does not signify a lack of connection to or reverence for a place. Perhaps a hypothetical situation may lend some clarity here. For example, if the inner sanctum of St. Peter's Basilica in Vatican City that only high-ranking priests would have access to were demolished, that destruction would impact Catholics around the world, even though they'd never be allowed to enter there themselves. Merely seeing pictures or just knowing in their hearts that a part of their sacred place was gone would hurt. And that is a built environment that can be rebuilt. Mauna Kea was born from Arakua and can never be fully restored. The inner sanctum of our church has already been breached. Aside from the existing 13 research facilities that have already caused disruption in this wawakua, the TMT will be built upon untouched conservation designated land.
3 minutes.
What about this use is consistent with the conservation district? Last thing I wanted to say was somebody mentioned earlier the Constitution Article 7. I just wanted to point to the recent Supreme Court ruling from Uncle Kuching and Auntie Max Ha'ulelio's case on Pohakuloa that interpreted that that there's an affirmative duty to preserve and protect traditional, customary, native Hawaiian rights, and so this body has an opportunity to follow that and make good on that. So mahalo, please declare. Sorry.
Ms. Harden's a little bit hard of hearing, Mr. Hakoda, so just try wait. Kalamai.
Sorry, in summary, please support the petition before you today.
Thank you. Are there questions for the witness from the petitioner?
I just have a small question, just I think might help clarify the record. You said that KAHEA was a TMT party to the TMT contested case. Did you call Ku'ule Higashi Kanahele as a witness, and she was not a party?
We did. So KAHEA was a party, and Ku'ule was a witness of ours.
Thank you. That's all.
Commissioner Okuda.
So, your organization was a party to the TMT action that ended up ultimately at the Hawaii Supreme Court.
Yes, that's correct.
Okay. And you know, I'm sure all the attorneys or possibly other witnesses might comment on this. So, you know, my question doesn't say that this actually is the rulings of the Hawaii Supreme Court in other cases. But if the Hawaii Supreme Court has an opinion that says that a motion for or a petition for declaratory relief like this cannot be heard by the Land Use Commission to overturn another agency's decision, and I'm just saying if that's the holding of the Supreme Court in another case, I mean, do you believe that the Land Use Commission can ignore a ruling of the Hawaii Supreme Court?
If I'm able, I'm going to decline to answer that because I'm not an attorney, so I don't want to interpret a legal question.
Okay, well, if just as a general proposition, do you agree that even if we personally might have serious doubts about not only the wisdom but the procedure and the practice that the University of Hawaii has followed with respect to management and use of the Mauna Kea Summit, if we see a direct ruling by the Hawaii Supreme Court that says, you know, we cannot second guess another agency's decision, do you believe that as a matter of public policy we should just ignore that ruling?
Again, I would hesitate to answer that question, just number one, because it's hypothetical, but number two, because I'm not an attorney, so I don't understand well just where you can make a determination and where the court makes a determination.
Yeah, okay. Me personally, that's one of the issues I'm kind of struggling with now, so I just wanted to know your input if you had one. Okay, thank you, Chair.
Can I offer one clarification to that? The Supreme Court ruling in the TMT case did not rule on land use law issues.
Yeah, but, and I guess I'll get into it or ask the questions of the petitioner's attorney, but there is another Supreme Court case which seems to suggest that that might be the rule, and so I was just seeing if you had any input which might help clarify the issue that I'm struggling with. Thank you, Chair.
Mahalo.
Thank you. Are there further questions? I have a few. Some relate to Commissioner Okuda's questions, some relate to your testimony directly. You said that it was, I believe, I'm paraphrasing, uncontroverted, that there were significant and adverse impacts from the collective development of the Summit of Mauna Kea in the record. Is that in the record of Mauna Kea 1 and Mauna Kea 2 that KAHEA was parties to?
It is. It comes from the NASA Keck Outrigger EIS, and it also appears in the TMT's EIS statement as well.
But I think you just said it in response to Commissioner Okuda's question. Was any part of the proceedings that led to the Mauna Kea 2 decision, did the BLNR or subsequently the Hawaii Supreme Court rule on whether there was a violation of Chapter 205?
As a non-lawyer, I'm not sure, but my understanding is they did not.
So your participation, you never heard anybody actually ask this specific question, whether the Chapter 205 within the control of this commission had been violated. Is that correct?
That is correct.
You've said something that I've heard a number of witnesses say, which is you want them to be required, the University of Hawaii or the BLNR to be required to apply for a district boundary amendment, but you would oppose such an amendment.
Yes.
Is that, have I heard that correctly?
Yes, that's correct.
If the University of Hawaii and the BLNR, by their own volition or some other means, ended up applying for a district boundary amendment to at least encompass the existing developed area of the summit, do you understand that if we grant a petition to amend the district boundary amendment, we can place conditions in, but if we do not grant it, we cannot place conditions?
If you do not grant the...
So say the University of Hawaii came and applied for an urban district boundary amendment, and say we said, yes, we're amending it into the urban district, just the existing footprint of the the developed area, not even the whole astronomy precinct. If we granted that, we could put conditions saying no more than a total of X square feet, no more than a total of X number of telescopes, no more than, certain conditions that we place when we make this irrevocable change into the urban district. But if we reject it and we say, no, we don't think it's appropriate for the urban district, what would happen would be it would go back to the BLNR. This jurisdiction as a conservation district. Are you understanding that sort of dynamic that we face?
I am now that you just
Okay.
explained it. Mahalo.
Okay.
I think part of the problem is that they should have asked before they built, and so now that they've already built, it puts everybody in a bit of a conundrum because they sidestepped the planning process where conditions could have been put in place long ago, but they weren't, and so now we're in this situation.
I would wholeheartedly agree with that point.
Following up on the chair's question, and this goes to the legal doctrine of res judicata, or to put it in plain English, if something has been litigated or could have been litigated in a prior case, that ruling or outcome of the prior case will bind the parties in later cases. So my question is, just so that I'm clear from your testimony, in the prior Mauna Kea TMT litigation, which ended up ultimately at the Hawaii Supreme Court, was the issue of whether or not the development violated Chapter 205, was that actually litigated or not actually litigated, based on your recollection?
Based on my recollection, it was not litigated, but as I said, I'm not an attorney, so I don't want to make like I know for sure, but
Okay.
my understanding is it was not.
Okay. Can you present any facts which indicated that any of the parties were prevented from litigating that issue? If you know.
I don't know.
Oh, okay, thank you.
Any further questions for the witness? If not, thank you very much.
Mahalo.